Proposed changes to the Canada Transportation Act have airline passenger advocates sounding the alarm. The changes, encompassed in Bill C-49, would double the time passengers may have to sit on the tarmac before they disembark. The bill also says the mechanical failures would not require airlines to compensate passengers for delays. C-49 was passed in the House of Commons last fall and is currently before the Standing Senate Committee of Transport and Communications. Gábor Lukács is an air passenger rights advocate. He testified before the committee earlier today, and he joins us from our Ottawa studio. So, Gábor, tell me a little bit more about what you said at that committee in terms of your issues with this.
Good afternoon. I was asking the committee members to amend Bill C-49, which is the bill currently before the committee, to take out the provisions that would allow airlines to keep passengers on the tarmac without water or food for 3 hours and replace that with a 90-minute limit, which is the current Canadian standard. I was also urging senators to amend the bill in such a way that airlines will continue to be required to pay compensation for delays that are caused by their own maintenance issues.
Those are two very significant issues. I mean, one of the reasons that this whole discussion began was because of that Air Transat flight that kept passengers sitting on the tarmac for 6 hours. Tell me why, in terms of most Canadian flights and how long they would allow their passengers to sit there at maybe 90 minutes, why would the bill want to make that longer?
That is a question that I would very much like the government to answer. We cannot imagine any reason why Canada's existing standard of 90 minutes should be doubled. It would harm passengers. We have not heard any complaint about this standard for the past 10 years for which it has been in place. And we find it both unreasonable and inhumane to double the amount of time to 3 hours. Just imagine for 3 hours, you are stuck on a plane without water, without food, possibly with clogged toilets. That's not what Canadians deserve.
And then to the issue of compensation, when an airline has in the past, say, provided some kind of compensation, if the issue is their issue, if it's, for example, mechanical, and they want that gone too.
Currently, under the Carriage by Air Act, which incorporates an international treaty called the Montreal Convention, airlines are required to pay compensation for damages caused by their own maintenance issues. That convention applies to international itineraries, but those principles also apply to flights within Canada. Under the Montreal Convention, the airline's liability limit is $8,800 per passenger.
So this bill C-49, which is also kind of commonly called a passenger Bill of Rights, who decided the 3 hours, for example? Who decided no compensation from it? How did that get in there?
We don't know how those items got in there, although we certainly suspect that this was written by the airlines for the airlines. The Minister of Transportation, Marc Garneau, admitted on December 12th before the Senate committee that this bill contains no air passenger Bill of Rights.
But it seems more like an airline Bill of Rights. Well, how much change?
Yes.
Yeah, go ahead.
Indeed, this bill serves the private interest of airlines and not the passenger's interest.
Are you optimistic that in terms of, speaking there today and the fact that, the transportation minister is saying that these regulations can further be developed by the Canadian Transport Agency, are you hopeful that there'll be change?
I'm hopeful that Senate will amend Bill C-49 because the provisions that are currently before the Senate are so harmful to the public that this is clearly a case calling for a sober second thought. If the bill passes in its present form, I don't trust the Canadian Transportation Agency at all. That governmental body is known for its cozy relationship with the airlines, for leaking out documents to airlines before the public is informed, and for not serving the public interest. It has been also criticized by the courts, including the Supreme Court of Canada, for its conduct.
Is there anything in this bill that looks after passengers?
The provisions that relate to carriage of musical instruments would be in addition to the rights of passengers. Other than that, I would say that it either just codifies some status quo, but mostly, predominantly, it claws back on our existing rights.
Gábor Lukács, we'll leave it there, but I know we'll have more discussion on this moving forward. Thank you.
Thank you very much for having me.